They do.
Mr. Sussman, do you have the opportunity to read the probation report?
Yes, sir.
Is there any legal reason why a sentence would not be imposed today?
I believe there is. And I've made that clear in the appellate division. I believe there is a legal reason why sentencing cannot be imposed today. That matter is still pending in the appellate division on my application for writ of habeas corpus. There's been no stay of the sentence, however, so the court, in that regard, likely can sentence. I believe the court should exercise its discretion and not sentence until that matter is resolved in the appellate division. People did ask for a stay, or not a stay, but a continuance of their date to respond to those papers, which was set by the appellate division for the 5th of September. They asked for a delay until the 7th to respond. I haven't heard back from the appellate division with regard to that, but I'm assuming that application is granted. I did send the appellate division a copy of this court's August 31st, 2018 decision denying my motion, post-trial motion in this court. So that court has an advantage of this court's thinking and reasoning, which we, of course, challenge.
Mr. Ford.
Your Honor, I believe there is no legal reason why the sentence can't proceed today, and it's the people's recommendation that the sentence does proceed today. I have with me a copy of the habeas corpus order to show cause that Mr. Sussman is referring to. He is correct in that it does not include any type of temporary restraining order or any language that would delay these proceedings. It appears the relief that Mr. Sussman was seeking pertains to bail pre-sentence. It's true that the application will be mooted out if the defendant were to be sentenced today to either incarceration or not incarceration. But in any event, given that the order to show cause does not include a temporary restraining order, and the court was aware that the sentencing proceedings would be occurring and did not issue that order, it appears to be consistent with the appellate division's order that the sentence proceed today, and it's the people's recommendation that we do proceed today.
Just if I might briefly.
Just to be clear, the appellate division is aware of September 6th as a sentencing date.
In Mr. Sussman's papers, he, I believe, incorrectly gave the appellate division the impression that the sentencing date was to be September 4th, but they were aware that it was going to be this week. I believe there's a typographical error in his paper.
All
Mr.
that's,
Sussman, yes.
all that's accurate. My position is very simply this. The basis of the application is not mooted by this sentence. If the court were to sentence Ms. Ryan today, my view is that a writ of habeas corpus as filed would be as applicable today or tomorrow as it is today. The underlying issues, which I'm not going to rehearse here, they're essentially similar to those which this court already decided, are still opposite, one way or the other. In other words, if this court were to decide the sentence and that application for writ of habeas corpus was granted, it would be granted because Ms. Ryan remains, as she was yesterday, incarcerated. The issue is whether that incarceration is or is not constitutional. Our application obviously says it is not, based on the factors we deduced. The court's opined on that, I understand that. It's before the appellate division now, which has not rendered a decision one way or the other. It's also accurate, and I said that originally, there was no stay of sentence. So I'm not arguing that there is a stay. If there was a stay, we wouldn't be arguing about anything. I'm suggesting to the court that in its discretion, given the timing involved, given the fact that my client is going to go back this morning to the Orange County jail, you're not going to release her as far as I know, I think the sentence should be suspended or adjourned until the appellate division has opined on the issue. That's the only point I'm making.
Your Honor, I don't necessarily agree with Mr. Sussman's legal reasoning on that, but since his position apparently is that the sentence, if Your Honor does impose sentence today, it doesn't moot out the application, that is a further reason why there's no reason to delay the sentence. And counsel seems to be conceding it wouldn't affect that order. And for all those reasons, the people are recommending that sentencing proceed today as scheduled.
And so we shall. Sentencing shall proceed.
Mr. Sussman, should fire a sentence?
Excuse me, yes.
Thank you. People on the recommendation?
Yes, Your Honor. As the court is aware, the defendant has been convicted of 10 felony counts of aggravated cruelty to animals and 10 misdemeanor counts of overdriving, torturing, and injuring animals after a bench trial that Your Honor presided over. As the court is also aware, the maximum sentence for the felonies in this matter is 2 years incarceration in the Orange County Jail on the felonies and 1 year incarceration in the Orange County Jail on the misdemeanors. And unfortunately, the law provides that since they are definite sentences, those sentences may not run consecutively. Therefore, the court has to determine where in the continuum of permissible sentences this defendant should be sentenced to. It's the people's position that she should be sentenced to the maximum allowable under the law for the following reasons. One is, as the court knows from presiding over the trial, this was an ongoing course of conduct. This was not an isolated incident. This was horses being starved to death, which is a particularly horrific way to die, and which in fact was a method of dying that was referenced when they passed the felony statute to begin with. That starvation by itself was determined to be a particularly sadistic method of killing animals. As the court is aware, 9 horses starved to death in this case, and 1 horse survived solely because it was rescued by the Hudson Valley ASPCA, a volunteer rescue organization, and the Town of Goshen Police Department. I'm happy to report that that horse, after being rescued, is doing fine. There was nothing wrong with that horse other than the conditions that this defendant was keeping that horse in. I'm also happy to report that not only is the horse thriving after leaving the defendant's control, but her son, who testified at the trial, is also similarly thriving after leaving the defendant's household. This defendant testified twice at the trial. She used the word that she was somewhat in denial over the conditions of the horses. She was living there. The testimony is she didn't have a job outside of the home. She knew everything that was going on with those horses. She was the one that was responsible for those horses. And she tries to blame her son, but she was the one ultimately responsible. In the pre-sentence investigation, it is evident that her being somewhat in denial continues. The PSI states that the defendant minimizes her involvement in the instant offense and uses her health as an excuse for the instant offense. The defendant appears to lack any regard for the law and the safety of the community or the case or others' lives. The testimony throughout the trial showed that the defendant, in her care of the horses, would let them roam free onto other people's properties. In short, Your Honor, she was inconsiderate to her neighbors, she was cruel to her child, and she was downright sadistic to the horses. And it's also evident from the testimony of the case that her intention was to get rid of some of the horses, and that the method she chose was to purposely starve them to death. So the people are recommending that with respect to counts 1 through 9, that the defendant be sentenced to a term of incarceration of 2 years in the Orange County Jail. For count 10, which is also one of the felony counts, the people are recommending that the defendant be sentenced to a conditional discharge, one of the conditions being that she not be allowed to own or care for animals. The reason the people are recommending that, Your Honor, is in the event that there is a stay of the sentence by the appellate division, the people are going to recommend that the conditional discharge not be stayed. The people are recommending that for counts 11 through 20, which are the misdemeanor offenses, that the defendant be sentenced to 1 year incarceration in the Orange County Jail. Also, consistent with the pre-sentence investigation, the people are recommending that Your Honor sign a restitution order for Equine Rescue Resources Incorporated, which was the agency that took care of Seamus. That bill, Your Honor, is calculated from the date of the search warrant execution through the day that Mr. Sussman and his client relinquished ownership of the animal in court. So it's not for the entire period. It's just from the date of the search warrant to the day in court when custody of that animal was turned over to that agency. Your Honor, we're also requesting that the court sign an order pursuant to Agriculture and Markets Law Section 374, subdivision 8C. That section states, a court may additionally order that the convicted person or any person dwelling in the same household who conspired, aided, abetted in the unlawful act, which was the basis of the conviction, or who knew or should have known of the unlawful act, shall not own, harbor, or have custody of control of other animals other than farm animals for a period of time which the court deems reasonable. As Your Honor is aware, since these are felony convictions, certainly if the defendant had been sentenced to probation, 5 years would be the term. The people believe that a 5-year order on this is appropriate and certainly would be considered reasonable under all of the circumstances. We are also recommending that the court inform the defendant after this conviction of her obligations under local Orange County law, which is that she must register with the Orange County Animal Abuse Registry, which is maintained by the Orange County Sheriff's Office. The people will be notifying the Sheriff's Office of the sentence in this matter. If the defendant is incarcerated, we will notify the Sheriff of that. If the defendant is not incarcerated, then I'm going to request that the defendant be informed that she must notify the Sheriff's Office regarding her conviction so that she can register for that registry, which will prevent her from owning any animals in Orange County. Thank you.
Mr. Sussman.
May it please the court, good morning, Your Honor. As the court knows, our view of the case is rather diametrically opposed to the people's view. I think much of what the people have said on the merits is meritless and not supported by the record. I think the record supports an entirely different view of what happened here, and I'll briefly summarize that since the matter is being transcribed and counsel took the occasion to essentially restate the premises of his case. In my view, what the court is faced with here is an individual who had a history of owning horses, a history which was unremarkable. She further had various physical and mental health issues, some of which are detailed in the pre-sentence report. She had a son who, she indicated in the pre-sentence report, and I think was clear from what we heard here, had some serious abuse issues. That is, substance abuse issues. She was attempting to assist her son in various ways, and one of those was to give him a sense of responsibility for these animals which he'd grown up with. Our son moved back to the home. It was essentially a condition and contract made that he would take care of the horses. She was physically impaired for parts of those times, but more importantly, perhaps, with her supervision, she understood he was taking care of the horses. There are literally 100 text messages, probably many more, in which her efforts to have him take care of the horses, her directions with regard to the care and feeding of the horses is chronicled. The people's theory of the case never accounts for that in any form or fashion, or put it. She was obviously concerned about the horses, and she was concerned about her son. We believe that what occurred here is not that the horses starved over a long period of time, but rather that in late March of 2017, the horses died because they ingested antifreeze, which was provided by her son. And we believe that that event occurred, and that when my client then saw the horses, was totally shocked by what occurred. Essentially, as she explained in the pre-sentence report and at this trial, due to the weather conditions and other things, her psychological response was made numb and did not deal with the situation appropriately. And I've never argued to the contrary. Her treatment of Seamus followed, and I believe that treatment, as we indicated in trial, was problematic. And I believe it was problematic in large measure because of her response psychologically to what she had seen and what she knew was going on in her farm. The point here is very simple. I do not believe that she intentionally killed the horses with respect to the felony count. I do not believe that people established that. I do not believe that conviction will stand. With regard to the other 9 of the 10 horses, I don't believe that she engaged in any sort of overdriving or failed to sustain the horses. I believe that when food was necessary, she ordered the food, whether it be hay, grain, or other supplements. I believe that's what the record convincingly shows. I believe she was concerned about watering the horses, had the water system inside, had buckets outside. There was testimony about that amply in this record. Frankly, this case comes down to some extent to credibility, and I think we all saw the young man. I believe his credibility is subject to extensive question. I think that the credibility of his girlfriend is also subject to extensive question. I understand the court decided otherwise. Those matters will be reviewed, obviously, on appeal. With regard to the sentencing issues, the people, as is now known, and was known really at the time, took the position that they would agree several days into this trial to a plea and sentence my client to 1 year maximally in incarceration. The court rejected that agreement, which is now a matter of record. The people were satisfied at that time with that period of incarceration is sufficient. They did not want to proceed with the cross-examination of the young man. If the trial proceeded, frankly, I understand why they didn't want to proceed with this cross-examination, because his testimony was all over the place, absolutely all over the place. He did follow his mother's directions as they were written. He did follow his mother's directions. It was, frankly, from my point of view, as an attorney for 40 years, a disgrace, and I believe that. I understand the court ruled otherwise. As I said earlier, that matter would have to be resolved in another forum. My client was a police officer for a number of years. She was disabled. She received a disability. She's been living on that disability since about 2000. She had the stable. She had used that stable, as you heard during the trial, for positive purposes for a number of years. Her mental health and physical health failing her, coincided with her son's return. The notion that she was abusing her son, as was gratuitously argued by the people, seems to me to be frankly absurd on this record. Her son was prosecuted by the same office for throwing his mother down a flight of steps, literally and physically assaulting her, which is what led to him being ousted from the property in March of 2017. I don't know of any basis for the people's claim that she abused her son. And I think that statement really ought to be stricken. I don't think there's any predicate for that either. The notion that he's doing very well now, he's been in treatment. That's not part of this record. He's been in treatment since his presentation in this court. He was in treatment before that. He's an unstable character. And again, since the court is the record, but since the people are raising it, I'll respond. I don't think it's appropriate for either side to be discussing it, frankly, but counsel makes representations that he's doing so wonderfully not true. My view here is very simple. I think the court, unfortunately, as I've argued, it's relevant to some extent because you're still here doing the sentencing, did err in not making a disclosure. I think that disclosure was particularly pertinent given the fact that this is an animal abuse case, which attracted a huge amount of attention in this community. The court was fully aware of that, and I believe the court, wife does have an interest, although I understand the court disagrees, and that'll have to be resolved at a higher level. What an interest means, whether the interest is apposite here, and whether it should have been disclosed. I'm not suggesting that as a matter of law the court needed to recuse itself. I am suggesting that it was critical that the court disclose that so my client can make an informed, intelligent decision on whether to take a bench trial. In a very difficult situation, because a case like this with photos and the like would obviously be very hard to try to a jury, and we understood that. However, a different judge could have been assigned. He did not have that, what I believe to be a conflict. And that matter should have been disclosed. It was not. We're here. The matter has not been saved. I believe the court should, as always, leaven an appreciation for the facts with the person. My client has no prior criminal history. I do not believe the evidence is that she intentionally killed 9 horses. I think that's a huge stretch in light of the emails, the texts that the court saw, the directions that she gave to her son. I don't think it's a stretch that will be sustained, and I don't think it should be the predicate for a verdict in this case. The expert witness who the people paid was unable to tell us definitively when the horses died. They could have died in March, which is our theory. They could have died in December. They could have died in between. No one testified with respect to the causation of the deaths of the other 9 horses. It's sheer inference that they died from starvation as opposed to something else, and it's not proven beyond a reasonable doubt on this record. Simply not. I believe the charges overlap. I do think there's felony charges here that are totally inapposite. I think the misdemeanors likewise are not, but I don't believe that a person should be convicted of both. I think it's inconsistent, and that'll also have to be raised and decided. So While I'd asked the court not to engage in sentencing today, to use its discretion to let the second department decide whether it was this court that should be doing the sentencing, the court's decided not to proceed in that direction. Obviously, we'll now have the discretion to impose sentence on my client. As for restitution, we did not have prior notice of the restitution. I have not had a chance to study the demand for restitution. I recently had a hearing in another restitution case with an animal case where the restitution demand was out of sight. It was not justifiable. I would like an opportunity to review the demand here and submit any opposition within a week to the court rather than having that imposed today without my having that opportunity. And I did mention that earlier to the board. Other than that, I appeal to the court to do the sentencing for whatever mercy it feels it can extend in light of the circumstances. Thank you.
Your Honor.
Mr. Bork.
Yes, if I could just clarify something based on Mr. Sussman's statement. When the people are making reference to the defendant being cruel to her son, we're referencing the trial testimony about the son repeatedly asking her to provide more sustenance for the animals or to get rid of the animals. We're referring to her repeated directions to him to dispose of the carcasses of the deceased animals, and that's what we're referring to as the cruelty to the son. Thank you.
Anything further, Mr. Sussman?
No, Your Honor. That's right.
Ms. Ryan, you have the opportunity to address the court if you would like to add anything in addition to what Mr. Sussman has said on your behalf. Mr. Bork has touched on a number of points that I wish to make. However, Ms. Ryan, you were the owner of the animals, the owner of the property. You operated stables, as has been stated. In fact, you acknowledged on several occasions you considered the horses to be pets. A pet owner has a strong obligation to take care of their pets. You ceded your total responsibility for the care and custody of these horses to your son. It's borne out in the emails, in the testimony. It's even borne out in what Mr. Sussman has just said about your son. Your house, where you were not feeling well for a certain period of time during this, is extremely close to the barn, a few hundred feet at best. It's my understanding, my recollection, you never went down to see how your son was doing with the horses until it was way too late. You exchanged the texts with him, do this, do that, you're not doing this, etc., etc. You probably would strike that. In your statements, when you had the opportunity to show some type of remorse or feeling, you told the probation officer that I wish there were better programs for these kids to get help, blaming it all on your son's heroin addiction. Yet, he stayed living in your residence with one of the other witnesses who was there who testified, not favorably. You didn't do anything at that point. You just allowed him to, on your behalf, persist in a regimen of minimal food, basically lack of water, not cleaning out the stalls so that the horses were in at least 18 inches of accumulated manure. And then, almost out of the blue, this theory of the horses being poisoned by antifreeze by your son, apparently, because you didn't want to take care of them anymore. There's no credible testimony that supports those statements. What there is that this, in all my years in county court, 12, all my years before, it's hard to find a case even in some of the homicide cases I've presided over, where such inhuman behavior was exhibited to your pets. I must say that I disagree with the way the legislature has decided to treat this type of offense. It's extremely unusual in a statute to put in that the sentence can only be a definite sentence, which means no state prison. If ever a case of animal abuse cries out for a lengthier term than a maximum of 2 years in the Orange County Correctional Facility, this is it. This is a heinous offense. It's hard to say that it was not intentional, whether medication induced to some degree, or whatever this malaise that you allege to have been suffering from during a period is, there's no defense that you had your son involved. He was the last person from anybody who could have helped you that should have been. And that is your responsibility. It is a sentence of judgment of the court. As to counts 1 through 9, the aggravated cruelty to 2 animals, you are committed to the Orange County Correctional Facility, serve a definite sentence of 2 years on each count. All of those sentences to run concurrently. On count 10, the aggravated cruelty to animals, I will impose a conditional discharge that you are not to own, harbor, or have custody or control of any other animals. And the language says other than farm animals. I am striking that based on your own testimony that these horses were not farm animals, they were pets. And that time, the time frame for that conditional discharge as applied on count 10 will be 3 years. It is a sentence in judgment of the court on counts 11 through 20. He failed to provide sustenance and the other charges that are contained in there as a Class A as an Adam misdemeanor. The sentence is 1 year in the Orange County Correctional Facility. All of those sentences to run concurrently, as well as concurrently with the 2-year sentences previously mentioned. May I see that order that you referred to, Mr. Bork?
Yes, I'm not sure, the rest.
No. We'll deal with that in a moment.
I have a section, I don't have an order, proposed order, I have a section of the statute showing the language for the agricultural markets law order that I'm handing up to the court.
I actually have that as well. I will take that. Pursuant to section 300, strike that. Is the further order of the court that you are not to own, harbor, or have custody or control of any other animals for a period of 15 years. There's a surcharge of $325, one $50 DNA fee, and the restitution matter we will schedule a hearing for as requested by counsel. Foregoing constitutes the sentences of judges of the court.
Mr. Ryan, we have a grant of appeals to the television second call within 30 days, and in addition, upon proof of the financial ability of retain counsel to pay the costs and expenses of the appeal. You have the right to apply to the television for a trial of counsel. I believe the prosecuting appeal is a full person with dispense with the permit. The television is located at 45 Over Place over Moving Road 11201. I'll see you. That's October 2nd. 2 p.m. for the hearing.
Can I just have one moment, Your Honor, to speak to a possible witness for the hearing?
Yes.
October 2nd is fine for the people.